Good afternoon, everyone, and thanks very much for having me at this session to look at a very topical and very difficult issue, which is the implications of councils going, quotes, bankrupt. Of course, unlike corporate bodies or commercial bodies, local authorities can't actually go bankrupt, but the equivalent is the issuing of the Section 114 notice, and that's the theme of today's talk. Just to introduce myself, some of you will know me already, but for those who don't, I'm a barrister. I practice at 39 Essex Chambers. We are a very large set of barristers who cover a wide range of civil law areas, and I specialise in public law, so the law involving the interaction between the state and individuals and companies, and I particularly specialise within that field in disability and children's rights issues. And that reflects my background. Before I came to the bar, I worked in the voluntary sector alongside Contact and other charities, and I was the campaign manager for the Every Disabled Child Matters campaign just before I became a barrister. So I've got hopefully quite a good insight into some of the realities of life for families of disabled children and young people themselves, gained both as a barrister but also from working in the voluntary sector. The focus of today's session is intended to be a practical one. We've got 2 hours. I'm going to allow everyone a short break, to coin a phrase, at 1 o'clock, because I think listening to me talk about the law for more than an hour is cruel and unusual. So I'm definitely going to give us a pause for refreshment halfway through. Really welcome questions and comments. The chat function is available for everyone at all times. Please post in there, and Helen and colleagues will keep an eye on that, and I will stop at various points and see if there are any questions there. I'll also, at that point, invite anyone to ask any questions orally. You can then please put your virtual hands up, and I will allow people in at that stage. I would suggest that questions are asked anonymously. I won't name anyone who puts a question in the chat. This session is being recorded and could be viewed by anyone, so it's probably best if questions are asked anonymously. But if you want to say who you are and where you're from when you ask a question live, you are welcome to do so. The other bits of housekeeping, I hope everyone's now familiar with how Zoom works. Your menu at the top of the screen should give you your options if there's anything that you need to do in terms of contacting us, perhaps through the chat. And these slides will be available after the session as well. So moving forward, when we talk about these notices, Section 114 notices, what are we talking about? Well, it's Section 114 of the Local Government Finance Act 1988, and I'm going to hazard a guess that very few people on this webinar have looked at the Local Government Finance Act. It's probably not everyone's preferred bedtime reading. What it does in Section 114 is require the relevant officer, the Section 151 officer, as they're known, the Chief Finance Officer of local authorities, to make a report if it appears to them that the authority has made or is about to make a decision which involves or would involve the authority incurring unlawful expenditure. And in practical terms, what that means is spending more money than the council has, because it's now unlawful for a local authority to exceed its budget. So if a local authority expects its expenditure, or the relevant finance officer expects its expenditure to exceed income for a particular financial year, then the Section 114 report has to be made. There's no discretion. The Chief Finance Officer can't choose not to make that report. They have to make it if they consider that that's the position that the council is in. There have been a number in recent years, perhaps unsurprisingly, given the long period of austerity in local government finances that we've had. Some of the most notable Section 114 notice authorities have included Birmingham, Croydon in South London, Thurrock in Essex, Slough, Woking, Northumbria. The list goes on. And perhaps even more concerning is that the vast majority of councils are now saying that their reserves are running out. And I found an article from earlier this year, January 2024, suggesting that at that point, 26 councils were estimating themselves to be at risk of having to issue a Section 114 notice in the next 2 years. So it's a very timely topic that I'm being asked to speak about today. We may well have people on the call who are from local areas which have issued or are currently under a Section 114 notice. And of course, experience from those colleagues would be very valuable. Please do share in the chat what has happened in your area if that does apply to you. In headline terms, what the Section 114 notice does is it freezes, quotes, discretionary expenditure. And what that means is that some council expenditure is not mandated by legislation. They are free to spend money, for example, on collecting the bins more frequently, but they don't have to do so. And so immediately, as soon as Section 114 notice is issued, all of that discretionary this expenditure is supposed to and must stop unless it's specifically authorised by the relevant officer. However, local authorities are required, of course, to continue meeting their statutory duties. And so that's going to be a major theme of today's talk for our group, Disabled Children and Young People. It's going to be very important to understand if you're in a Section 114 area or an area that's at risk of a Section 114 notice, what are the duties that must be complied with regardless of the council's financial position? Because that's not always obvious. It's not always well understood. And one example that I'll give later on is school transport, where there are different statutory duties to provide school transport at different ages and stages of a young child or young person's educational career. And so in a Section 114 area, for example, there will still be a requirement to provide transport to children of compulsory school age where they meet the eligibility criteria. There will still be a requirement to provide transport to adult learners where it's necessary to do so, even though all the discretionary spending is gone. And that's because those are duties which are not in terms affected by the council's financial position. And as well as freezing the expenditure at that point, the other key effect of a Section 114 notice being issued is that the council must then meet within 21 days and decide how to remedy the position that it's got itself into. Why have councils got into this position? Well, there's a host of reasons. I would suggest the most obvious is simply that they have been given less money by central government. But there have also been difficulties in relation to investments that were made partly to try and offset the effect of cuts in central government funding, some of which have not worked. Very prominent examples of that, people where councils effectively lost money on investments in the same way that a private individual might have done, and that then reduced the budget that was available. And also, of course, growing cost pressures, and people will be aware of that and will probably have heard councils complaining about the growth in demand for adult social care, and in our area, for example, the growing number of BHC plans, the fact that the extension of the scheme up to 25 was, it said, not properly funded, and so on. So it's a constellation of different factors, which has led ultimately to many local authorities using up their reserves and not being in a healthy financial position. How long is this going to last for? Well, that's a political rather than a legal question. But from what I've seen, there's no suggestion that there's going to be radical investment in local government if Labour win the next election, for example. And so all the articles and coverage I've seen suggest that the current situation is likely to continue, perhaps with some differences, but at least in broad terms, fiscal austerity is likely to continue for the foreseeable future. So these problems are not going to go away. What can a local authority do if there's been, if they found themselves in a position where Section 114 notice has to be issued? Well, the most obvious thing that they will do, and this is, of course, what gets the headlines, is they will cut any expenditure that they consider to be discretionary. For example, cultural activities, leisure centres, and so on. They will immediately stop spending that money so far as they're able to do so. And they will say, but of course, we are continuing to discharge our statutory duties. And one of the questions the forum may well need to get involved in is, well, have you understood your statutory duties in our area? There are other things that they can potentially do. None of them are particularly helpful, I would suggest. You can reallocate budgets with permission from the centre, something called a capitalisation direction, which allows capital budgets, so the local authority's budget for infrastructure, to be used for revenue expenditure. Of course, that's only going to be a short-term fix, as is selling off assets, the town hall or any other assets the local authority has. Of course, they can only be sold once, so that's not a long-term solution either. They can look to put up council tax, but the ability of a local authority to raise its own council tax has been limited, so that the maximum raise is 5% for those local authorities that have adult social care responsibilities, unless you trigger a referendum. I believe there have only been a handful of referenda. I think only one I can think of, and it was comprehensively lost. Unsurprisingly, people don't tend to vote for paying more tax. So local authorities tend not to even try to go above the 5% maximum. But as always, there are some exceptions. So the government can, if it wishes, permit local authorities to raise council tax by more than 5%. Croydon were permitted to raise council tax by 15% last year, Slough by 10%. And there have been some notable bailouts as well. Hackney issued a Section 114 notice under the last Labour government and were bailed out. Some other authorities under this government have received bailouts as well. But of course, that's pretty arbitrary, and no one knows whether they're going to get a bailout or not, other than through behind-the-scenes conversations. And so certainly local authorities can't rely on being bailed out by central government. Clearly, central government isn't going to want to establish a precedent that, don't worry, guys, if you spend all your money, we'll just come along and give you some more. Otherwise, the local authority's budget setting process becomes pretty much pointless. What also tends to happen when a Section 114 notice is issued is that central government will intervene, either by instructing the local authority to do something, or, as for example in the case of Birmingham, appointing commissioners to run the local authority for a period of time. So the local authority essentially gets taken over by central government. And this is really an important reality, because we can't not have a local government in a particular area. If there has been a failure, as it will be seen, to manage the finances, instead of in the business world, that company just goes bust and another company gets to have a go in the same space, the central government will take over the local authority very often and run it for a particular period. The local authority may well find itself reorganised. Northamptonshire, which was a very prominent Section 114 authority a few years ago, I was involved in a case about the closure of library services there during that time. That council no longer exists. It was broken up. So there is lots of things that can happen, many of which will be seen to be negative from the perspective of the council. But in reality, in terms of solving the problem, the quick solution is almost always cutting anything that is not seen as being mandatory expenditure. So the problem that creates in our area, and what I want to spend much of this session thinking about, is the nature of the statutory duties in relation to disabled children and young people. So the basic principle is that when Parliament passes an enactment involving social welfare, it will either create a power for the public body to do something or a duty for it to do something. So powers and duties are the key typology. And a power is expressed by permissive language, may. So a local authority may, a school may. That allows them to do something, but it also implies that they may not do it because it's a choice. So that's why it's a power rather than a duty. Whereas a duty that's expressed in mandatory language, usually must, sometimes shall, requires the thing to be done. But the duty is to do whatever it is that the words of the Act say you must do. And very often, duties are qualified, often by references to reasonable practicability, to so far as is practicable, that kind of language. And that then brings in the question of the resources that are available to do the thing. And that's particularly the case where the duty is a general duty. General duties are owed to the whole population or a group. For example, the duty in Section 17 of the Children Act is owed to all children in need, including all disabled children. But it's a general duty to have services for children in need in Section 17, subsection 1. It's not a specific duty to provide services to any individual child. And so, of course, the local authority can take account of its resources in deciding which children are going to get a service. So I've picked out two examples here on the slide of what you would call these kind of resource-dependent duties. The first one is the short breaks duty. So this was the duty that was put in place following all the campaigning with Every Disabled Child Matters and others, and is now found in the Breaks for Carers of Disabled Children regulations, which sit underneath the Schedule to the Children Act. And the regulations say that a local authority must provide, so we can see that it's a duty, so far as is reasonably practicable, a range of services which is sufficient to assist carers to continue to provide care or to do so more effectively. So that is, and it's quite a common construct in modern social welfare law, a sufficiency duty. You can see the word on the slide, sufficient there. So there must be a sufficient level of a particular service. There's a sufficiency duty for childcare. There's one for children's centres. Here's the one for short breaks. But we see that it's qualified. It must provide so far as is reasonably practicable. And so I anticipate that a local authority that's where a Section 114 notice has been issued will probably say it's no longer reasonably practicable for us to provide any short breaks under this duty because we've got no money. Or it might say we have to cut the level of service in half, and that's what's reasonably practicable for us to do. So that decision to cut the services could be challenged, but it will be very difficult to challenge a conclusion that it's not reasonably practicable to do any more than X local authority is prepared to do in a context where they've run out of money, because the legislation allows, with that clause there, so far as is reasonably practicable, the local authority to take account of its resources. So that's an example of a general duty that is resource dependent. But there's also, unfortunately, resource considerations in some of the individual specific duties that are owed to individual children. And a very prominent example of that is the duty in Section 2 of the Chronically Sick and Disabled Persons Act, which is the key duty in relation to social care services for disabled children. So this applies to under 18s. And what Section 2 does is it takes the general duty in the Children Act under Section 17 and makes it specific for disabled children. The local authority must provide social care services to specific disabled children under Section 2 of the CSDPA. And that's why if you have an EHC plan, you will know that there's a whole section of an EHC plan which is about those services, because it is a particular duty to provide those forms of social care to qualifying disabled children. The problem, of course, is which disabled children qualify for a service under the CSDPA. If you look at the language, so the local authority must make any arrangements within subsection 6. So that's the service list, and it's very broad. It essentially covers any form of social care service other than accommodation. So short breaks in the community, domiciliary care in the home, assistance with adaptations, etc. That's all listed in Section 6. So a local authority must make any arrangements within that list that it's satisfied that it is necessary for it to make in order to meet the needs of the child. So that's the test. People will be well aware of, if you heard me talk about these issues before. Is it necessary for the local authority to meet this child's needs by providing any of the services in subsection 6? If it is, then they must be provided. However, it's very well established in the case law that whether or not something is necessary is a relative concept. So a local authority can decide one year that more things are necessary for them to provide than other years. And when we had the Section 2 duty in force for adults before the Care Act, there was guidance known as Fair Access to Care Services, FACS. And that required local authorities to set their eligibility criteria by reference to one of 4 bands: critical, substantial, moderate, and low. And some local authorities lifted their eligibility criteria up to critical only. So they said, we only find at the moment, because we're so short of money, that it's necessary for us to meet critical needs. And that really was essentially pretty close to life-threatening, life-endangering needs. And even if you've got substantial needs, we're sorry, we don't think at the moment it's necessary for us to meet those because we can't afford to. And that same principle, although there isn't the clarity that you've got in that guidance that we used to have for adults, that same principle applies for children as well. So a local authority is entitled to assess a disabled child under Section 17, to identify needs and identify needs that it would like to meet, but say, well, we find that it's not necessary for us to meet them because of our taking into account our resources. We consider they're not significant enough. And so what I fear will happen is that in areas where a Section 114 notice is issued, the eligibility criteria will be tightened, and that will be permitted under Section 2. There will obviously come a point where no rational local authority would conclude that it's not necessary for them to provide the service. If, for example, the consequence of that is that the child is going to, the family are going to fall apart and the child will end up being taken into care. But aside from those very extreme cases, it will be difficult to challenge a decision of non-eligibility, again, in a financial crisis, because the legislation does allow, and the case law says, and this is old adult cases, including the House of Lords decision in ex parte Barry, Gloucestershire Council and Barry, that local authorities can take into account their resources when they're deciding whether it's necessary to meet a person's needs. So that's the slightly bleak picture in relation to a large number of the statutory duties that we are concerned with. However, there are some other shining lights within the statutory scheme that are not resource dependent. So I've just listed a few here of the duties that a local authority would have to continue to meet in any case, including one where a Section 114 notice has been issued, because it's established that these duties are not resource dependent. So first of all, start with the most obvious, the duties in relation to EHC plans. Section 42 of the Children and Families Act requires that where a local authority is maintaining an EHC plan, it must secure the special educational provisions set out in Section F of the plan. And if the plan specifies health provision, then the relevant health body, which will now usually be the ICB, must arrange that provision. And those are absolute duties, as they've been known. They're not dependent on whether the local authority has got any resource problems or not. They simply must secure the educational provision. The NHS must arrange the health provision as specified in the plan. And there's a very important case involving North Tyneside Council, where Lord Justice Sedley said that there is no best endeavours defence for a local authority that's failing to secure the provision in an EHC plan. They can't rely on any external factors, the non-availability of therapists, the fact that they've issued a Section 114 notice. None of that effectively gets them off the hook of having to secure that provision at all times. So if you have an EHC plan, and critically importantly, if that plan is properly specified and quantified, then you will have an enforceable entitlement to that provision, regardless of the local authority's financial position. There's a few ifs in that sentence, of course. So one thing that we know is happening is that thresholds for EHC needs assessments and then decisions to issue an EHC plan are being raised. Questionable legality in that in those approaches. People may well be aware of the safety valve agreements that are in place in some local areas. There was recent work, very good work by IPSI, looking at what that means in reality in terms of commitments to reduce the numbers of EHC needs assessments and plans. And the law hasn't changed in that respect. So it's difficult to see how that can be done lawfully, but we await any judicial consideration of any of those arrangements. So there's a big if about whether you will get the EHC plan in the first place. And then, of course, the next if is whether it's properly specified and quantified. And what that means is that words like access to speech and language therapy or opportunities for small group learning are not present in the document. And instead it says things like 1 hour a week of speech and language therapy, or to work in groups of no more than 6 for half an hour a day, or whatever the wording would be that is appropriate for the child and based on an assessment of their needs. But unless the plan is properly specified and quantified, it will be impossible to enforce the provision, because access to simply means that the child has been somewhere near a therapist at some point. So there's quite a significant caveat to my enthusiasm for the Section 42 duty as being an absolute duty. But if you have an EHC plan that is lawfully worded, then you have the benefit of a specifically enforceable and absolute duty. The way in which the duty would be enforced would be through an application for judicial review. And that, of course, is another major problem, is bringing a claim for judicial review is not something that people are used to doing on a wet Wednesday. You need specialist legal advice to support you to enforce your child's rights, or as a young person to enforce your own rights through judicial review. And availability of lawyers is limited. One important point to note is that legal aid is now automatically available in the name of the child, regardless of the child's own resources. So that means that in principle, all disabled children are financially eligible for legal aid. And that's one of the two tests for whether you can get legal aid, the other being whether your case has merit. And if there's been a failure to secure provision in an EHC plan, pretty likely your case is going to have merit. So then the next challenge is, can you find a solicitor to help you who's got the relevant legal aid contract and some capacity? And I appreciate that's not straightforward at all. I do list some of the solicitors who work in this area on my Rights in Reality blog, and I can ask that that link is circulated. But if you can find a solicitor, then the Section 42 duty is one of the most straightforward to enforce through judicial review. Its neighbour in the Children and Families Act, Section 43, which is the duty to admit, is also not resource dependent. So if a school of every type other than an independent school that's not on the Secretary of State's list is named in Section I of an EHC plan, and college as well, of course, for older learners, then they must admit. Without more, they simply have to admit the child or young person. And if they don't like that, and if they don't think they should have been named, their only legal remedy is to judicially review the local authority and say you've acted unlawfully in naming us. And that has been done a few times, but again, it's a very rare occurrence. So in practical terms, in the vast majority of cases, once you have that school or college named in Section I, there is a non-resource dependent duty on the school or college to admit. And very importantly, for independent and non-maintained schools under Section 63 of the Act, there is a duty to pay the fees that that school or college are charging if they're independent from the state. I've produced an opinion with a colleague in Chambers, Fenella Morris, King's Counsel, and we say that that is a duty that essentially requires the local authority to pay whatever fee is being charged. Because if that fee is too much, then the local authority's option is to place the child somewhere else. But if the provider of the school says, we need £100,000 a year to educate this child, then the local authority needs to pay that if the school is named in Section I of the EHC plan. That opinion, I don't think, is universally shared by all lawyers, and we may well find that it's tested in court at some point. But it's another very important, I would say at least, non-resource dependent duty. So even if the local authority has issued a Section 114 notice, they will still have to pay the fees of any independent school which is educating children, their children, that have the school named in an EHC plan. There are other important education duties that are non-resource dependent as well, and I've picked out the Section 19 duty, which is really the safety net duty, the backstop duty. This is not in the Children and Families Act, this is the Education Act 1996, and it applies generally to all children of compulsory school age, so roughly 5 to 16, and it mandates that a local authority shall provide suitable education to any child of that age who is not receiving suitable education for any period, for any reason. So it's, as I said, a safety net that is designed to ensure that children don't just fall through the gaps and don't receive any education at all. And in a case called Tandy, another one of the foundational social welfare cases, it was held by the House of Lords that this duty is not resource dependent either. And so the education that's provided under it needs to be full-time, unless the child needs less, and needs to be suitable for their age, their aptitude, and their special educational needs. So there are lots of other examples, and perhaps we'll cover some more off as we go through and look at any questions in the chat, of duties that do not allow a local authority to take account of their resources, but they are special and they are precious. And I would suggest that any forum that either has a Section 114 notice of force in its area or fears that their local authority may have to issue one needs to be very aware of where these duties are and probably have a list to hand, because these are the ones that it's going to be possible to continue to enforce. So I will come out now of the slides just to see if there are any questions in the chat. And if anyone would like to ask anything live, please put your hand up. I don't have any questions in the chat yet. So does anyone have any questions to ask at the moment? Or else I will carry on. Let's see what we got in the chat now. Good. Okay. So it's a question about a particular local area's safety valve program. And I won't name the area, but the comment is that the safety valve program specifies the almost entire elimination of independent school placements. And the question is that potentially unlawful? And as always, the devil here would be in the detail. My view, and I'm not a judge, so it's just my view, and we'll find out if, as and when these cases go before a judge, is that there's nothing wrong legally with a local authority seeking to increase the availability of placements outside of the independent sector, i.e. maintain placements, academy placements, etc. And in so doing, reduce the number of placements in independent schools. The problem is when the exercise is conducted the other way around, when it's simply said, well, we're going to stop placing in independent schools. And there's been no commensurate investment in the maintained sector to increase capacity and increase availability and so on. Because when you get to the stage of individual children and young people, the statutory test is really clear for placement, that the local authority must comply with parental preference, particularly for a Section 41 independent school, one that's on the Secretary of State's list, unless it can rely on one of the exceptions, which would include the inefficient use of resources. And when we're thinking about more widely about parental preference in Section 9 of the Education Act, unreasonable public expenditure, and that which applies to all schools, all independent school choices. So if a parent comes forward and says to any local authority, I want X independent school for my child, and it's going to cost £100,000 a year, the local authority can say no, but only if it has a cheaper available option, which is suitable and adequate and sufficient to meet the child's needs. So you will hear, of course, from local authorities that there's no right to a Rolls-Royce education. We've all heard that one. That all that needs to be provided is what's adequate, and that's right. But what's adequate might be quite a lot, particularly for some of the children and young people with more complex needs. And I'm instructed in lots of cases where, in fact, there is only one placement that's been identified that can meet that child's needs, and the local authority doesn't like that and doesn't want to spend that kind of money, but it has no other option. And either it will concede that, or ultimately it will be ordered by the tribunal to name the school the parents want. And that's really unusual, of course. It's quite important to keep in mind that there's very few other areas of social welfare law where a tribunal doesn't just look at appeals on points of law from the primary decision, here, the local authority's decision on which school the child should go to. It actually steps into the shoes and decides for itself. And that's a very powerful remedy. And of course, the tribunal is beset with difficulties, not least delays. But once you get to the hearing, and once you have a tribunal panel looking at the evidence, they will decide what they consider to be an appropriate school. And so they will decide not whether the local authority has made a reasonable decision, as it would be in judicial review, but whether in fact this school can meet the child's needs. So long answer to a helpfully short question. To circle back to what I said at the beginning, it will very much depend on how the policy objective of reducing independent school placements is to be achieved. If there's just a ban on them being made, for example, it's very hard to see how that could be lawfully defended. So another very interesting question, what about multiple legislation? And an example that's given is transport for post-16s or under 5s, which isn't covered by the Education Act, but would be by the Equality Act. Well, just to challenge the question, actually, post-16 transport is the subject of statutory duties. There's a duty in relation to post-16 transport to have the transport policy statement, which sets out when it would be necessary for transport to be provided. And then for adult learners, there is a specific duty to provide that transport where it's necessary for them to do so. My view, subject to being told I'm wrong by a judge, is that it will be impossible to see how a local authority can put out a transport policy statement that says we accept it's necessary to provide transport to 60 and 70-year-olds in these circumstances and then not provide it. So in practice, I would suggest that that has created a duty to provide necessary transport to 60 and 70-year-olds as well. But taking the premise of the question, the Equality Act is hugely important, of course, in this context, because it mandates, again, that a range of bodies, including local authorities, don't discriminate against protected groups, including disabled children and young people. The problem, though, is that most forms of discrimination can be, or potential discrimination, can be justified. So if you take the example of direct discrimination, you can't come in this shop because you're disabled, that can't be justified. But thankfully, that's pretty rare. And so what we're much more likely to see is examples of indirect discrimination, policies, provisions that disproportionately impact on disabled children and young people. And if we identify one of those, for example, in the education context, 100% attendance reward policy, we would say that disproportionately impacts on disabled children who are less likely to be able to achieve 100% attendance. Then the question is, can the school justify it? And they have to justify it as being a proportionate means of achieving a legitimate aim. And although saving money is not itself a legitimate aim on its own, they have to be able to explain the discriminatory effect. Resources are highly relevant to questions of indirect discrimination. Similarly, a very powerful duty in the Equality Act is the duty to make reasonable adjustments. And that is perhaps the most powerful duty because it requires things to be done differently, positively, to improve access for disabled children and young people. But, of course, it's a duty to make reasonable adjustments. And so the cost of making the adjustment is relevant to whether it's reasonable to do it, as is the resources available to, in our case, the local authority. So in the majority of cases, the Equality Act duties fall into that basket of duties that are where resources are relevant and where it will be very difficult to challenge a Section 114 authority for not doing something where the reason it's not doing it is because it's run out of money on the basis that it breaches the Equality Act. But I'll come back to some thinking about that a little later on. Thanks for those questions, guys. I'll crack on for now. Just need to share my slides again. Hopefully you can all see those again. So a couple of other examples of duties that are not dependent on the local authorities' available resources. Section 17 of the Children Act. Now, I've talked about that briefly already, the duty that's owed to all children in need. And it's well established, not least by the House of Lords in the G. M. Barnett case, that doesn't create a duty to provide services to any individual child in need. But what their lordships said in the G. M. Barnett case is that there is a duty to assess every child who is or may be a child in need. So that would mean every disabled child is entitled to be assessed under Section 17, and that duty is not contingent on available resources. So if a parent of a disabled child or a carer of a disabled child says, I want you to carry out a Section 17 assessment, the local authority can only lawfully say, yes, we will do an assessment and then carry the assessment out. Also, because of the amendments that were inserted in 2014, Section 17 ZD, ZE and ZF of the Children Act require local authorities to carry out parent carers needs assessments, essentially on request. In fact, they're supposed to go out and proactively offer them to parent carers who might have needs. And there's no resource get out from carrying out a PCNA either. And Section 17ZF says that at the outcome of the assessment process, there needs to be a joined up decision about whether or not to provide services to the disabled child or the members of the family. And those, again, none of that is dependent on the resources. But that's a process. So those are process duties in the sense of they require a procedure to be carried out, as in an assessment process. And they require a decision to be taken at the end of that process about whether or not to provide services. But they don't say that that decision must be positive. And of course, in many cases, in a Section 114 authority, there would be a negative decision at the end. We are not providing any services because we've run out of money. So they only get families so far. There is an example, or several examples in the Children Act of specific duties that are not dependent on resources. And the one I want to highlight here is Section 20, which is the duty to accommodate. Section 20, subsection 1, creates duties to accommodate certain groups of children in need. And in subsection 1C, that includes those whose parents are prevented for whatever reason and for whatever period from providing them with suitable accommodation or care. And so that can, of course, include parent carers of disabled children who are no longer able to cope. It doesn't have to be unsuitable accommodation. It can be that they can't provide suitable care anymore, whether because of the child's needs, their own needs, a combination of the two, or any other reason. And in that situation, the local authority must accommodate the child for whatever period is needed to make that crisis go away. And they must accommodate the child in the placement which in their view is the most suitable for them, again, regardless of cost. That's Section 22 big C, 22C of the Children Act. So that's an important, again, safety net duty, backstop duty. But it's very clear that that duty only arises in very extreme fact cases. This was looked at recently in a case I was involved in called TS and Hackney. And applying the guidance from the very important case of JL and Islington, the court there said, well, Section 20 only arises when the parents are currently prevented from providing suitable accommodation or care. It's not about future crises, it's about actual crises now. And that therefore means, hopefully, it won't be relevant to the vast majority of disabled children and families, and that their care needs are being met in a much more planned and sustainable way. There is a power to accommodate in Section 20 as well. It's in Section 20, subsection 4, and that's often what will be used where disabled children are being accommodated away from home for longer periods, and the statutory guidance on short breaks says that in those situations it should be a Section 20, subsection 4 placement. But again, that's a power. There's no duty to accommodate children under Section 20, subsection 4. So I anticipate that, again, in a Section 114 authority, no such accommodation is going to be offered. Another area of law that I thought would be interesting to look at and think about here is human rights. Now, we still have the Human Rights Act from 1998. There's been no change to that. And what that does, as people may well be aware, is incorporate into our law most of the rights that are contained in the European Convention on Human Rights, the ECHR. And that includes, in Article 3, the prohibition on inhuman and degrading treatment, torture and inhuman and degrading treatment. And we might think that that's going to be relevant to, unfortunately, some of the situations that disabled children and young people might find themselves in. But the case law shows that, as you would expect, the bar for when treatment is deemed to be inhuman and degrading is set very high. There's a very notorious case involving a disabled mother, Bernard and Enfield, where the mother was left in what might be said in ordinary language to be wholly degrading conditions, but it didn't cross the threshold to Article 3. What it did give rise to, the court said, was a breach of her right to respect for her private life and her family life under Article 8 of the Convention. But the problem with Article 8 is that it's a qualified right, and that means that it can be interfered with if it's proportionate to do so. So a bit like the Equality Act, when you're looking at whether or not someone's Article 8 rights have been breached, the context and the resources that are available to the relevant to the public body are relevant to that question. And so I can again see many potential claims against the Section 114 authority saying, well, you're failing to provide care in a way that's leading to a breach of my human rights. being met with the defence of, well, you can't get over the bar for Article 3, it's not that bad. And we're sorry that we're not able to pay more respect to your Article 8 rights, but we haven't got any money. And the case law tends to suggest that that defence will succeed in broad terms, depending, of course, on the facts of the particular case. There are other highly relevant human rights within the ECHR and the 1998 Act, of course. One that's obviously relevant to this audience is the right to education in Article 2 of the First Protocol. But that's often described as a very weak right. It's a right not to be denied access to the education system that exists. So it's not a right, for example, to be educated in any particular school. It's not generally understood to be a right to have any particular quality of education. It's simply a right not to be excluded from the system as a whole. Sadly, of course, some disabled children and young people are entirely excluded from the education system. But in those cases, certainly where they're aged 5 to 16, they'd be covered by Section 19 of the Education Act. There would be a duty on the local authority to provide them with suitable accommodation, suitable education, in any event. So really the A2P1, the Article 2 Protocol 1 right to education doesn't add anything in those cases to the Section 19 duty. So put broadly, I would suggest that in the vast majority of cases, the human rights framework doesn't add to the specific obligations for our children and young people that have been enacted by Parliament over the years in the legislation that we've been talking about today. It may well be that a failure to educate, a failure to provide care, which is unlawful under those acts, is also a breach of a person's human rights. And that can be relevant, for example, in terms of claiming damages. But in terms of actually establishing a duty to do the thing in a Section 114 authority that is only complying with its mandatory duties, it's unlikely, I would say sadly, that the Human Rights Act is going to add anything. So those were just a few examples of duties that I thought it would be useful to look at for this audience. I'm very happy to take questions about other areas where there might be duties that would require a Section 114 authority to do a particular thing, even in a situation where it's only complying with its mandatory obligations. But I also was asked to look at a rather different question, which is whether you can challenge a decision to make a Section 114 notice. And to provide the spoiler at the beginning, I'm afraid the answer to that is yes in theory, but probably no in practice. So the theory first, it is a decision of a public body, and therefore it is amenable to, as the phrase goes, the lawyer's phrase goes, judicial review. So the High Court can, and if asked to, would consider the lawfulness of a decision to issue a Section 114 notice. However, I think in many cases, a challenge like that wouldn't get off the ground. Permission to apply for judicial review would be likely to be refused because it seems to be difficult to construct an arguable case of unlawfulness in that situation. There are two broad types of judicial review claim, one around the procedure, one around the substance of the decision. In terms of the procedure on Section 114, the very minimal procedural requirements, you'll recall that if the relevant officer considers that expenditure is going to exceed income, they must issue the notice. There's no obligation for them to consult anyone before doing that. So it would only be if they acted in a wholly unfair way, that in a way that I've actually finding quite hard to imagine, that a court would interfere in terms of the process. In terms of the substance, again, they must issue the notice if they consider that expenditure is going to exceed income. So where's the room to challenge? It's not a value judgment. It's not a question of reasonableness or anything like that. It's really quite, it's more a question of hard maths. They could have got the sums wrong, of course, and then it would be a challenge on the basis that no reasonable officer would conclude that that the expenditure is going to exceed income. But in the absence of something extreme like that, again, it's hard to see how Section 114 notification could be challenged. And as far as I can see, it has never been. The cases which cite Section 114, and there are only a few of them, are all cases where there's been a challenge to something bad that has happened after the Section 114 notification has been given, For example, my libraries case, WX and Northamptonshire, or a more recent case involving Birmingham that I'll talk about after our break. So you can, of course, try and challenge those subsequent decisions. They're new targets, new decisions, but it's going to be difficult in the context of the Section 114 notice, although the libraries challenge did succeed on certain grounds. But challenging the Section 114 notification itself seems to be practically impossible, I would say. Never say never. It's possible, it's conceivable that a local authority or a relevant officer could go so badly wrong as to require the intervention by the High Court. You would expect, if that were to happen, that a letter before action, which is of course the first stage before any judicial review claim can be issued, then the claimant needs to send a pre-action letter setting out what they say has gone wrong and asking the public body to correct it. You would expect that a case like this would be so obvious that it would then be corrected. But although I can conceive notionally of a situation where that doesn't happen and the parties end up in court, very difficult to see it happening in practice, in my view. So that's why I focused the talk on living with the Section 114 notice and what it is that parent forums are going to have to do in that unhappy situation. Of course, to the extent that parent forums can influence their local areas not to, quotes, go bankrupt in the first place, all well and good, but I expect that parent forums are going to have limited ability to influence that. And therefore, it is more a question of making sure that relevant officers and members are fully aware of the nature and extent of the statutory duties, and particularly these non-resource dependent duties that I'm touching on today, because the expectation will be that everything else is going to get cut. So having that conversation early and making sure that people are aware that, for example, they can't stop carrying out child in need assessments of disabled children, or they can't have a policy of not placing children in independent schools because they must place the child in accordance with the parental wishes unless one of the exceptions apply. The concern overall, I think, is that the levels of legal literacy amongst local authorities are variable, as we know. And people will be told, oh, well, we don't have a duty to do X, when in fact they either do, definitely, or at least may, because some of the duties are contested and their precise limits aren't yet defined in case law. So that's really the focus, I think, is what can we say to local authorities as a parent forum? You must carry on doing, notwithstanding that you've, quotes, gone bankrupt and issued your Section 114 notice. Okay, I'll come out again at this point and see if there are any other questions. I think there's one more in the chat at the moment. Yes, if levels of legal literacy are variable, where does the monitoring officer fit into the decision making? Well, that's a really helpful question. Of course, the monitoring officer is a very important figure in all of this. They are the officer who is required to ensure that the local authority acts lawfully. And they very much ought to be brought to their attention if, at least arguably, in the context of a Section 114 notice, the local authority isn't complying with its statutory duties, as it would be even if there wasn't a Section 114 notice. But again, my experience of monitoring officers is that their efficacy varies quite considerably, how effective they are in terms of challenging potentially unlawful conduct by the local authority. And I certainly wouldn't assume that just notifying the monitoring officer that something's gone wrong is an adequate alternative remedy to judicial review. In that situation, I would be saying, get solicitors to send a pre-action letter and make sure it's copied to the monitoring officer so they know that that's your case, but that if nothing is done about it, you can then take the next steps of going to court. And then a really helpful question, what are the duties on commissioners to consider the legislation such as the Children's Act? Well, my understanding is that if commissioners are appointed by central government, they take on all the responsibilities of the local authority. They're essentially running the local authority. So they will have, or the local authority they are running continues to have all of its legal duties. So the answer to the question is the same as the chief exec, the cabinet, the people who were running the authority beforehand. The imposition of commissioners doesn't in any way change the legal obligations on the local authority. It just changes the people who are making the decisions about how the duties ought to be discharged. Okay, does anyone have any other questions or comments at this stage? One more very interesting question. So local authorities that have essentially pre-eligibility criteria, so a criteria before they will carry out a child in need assessment, that the child has to have severe and complex needs, for example. So Professor Luke Clements and colleagues did some very good work on these kinds of criteria probably a couple of years ago now. And in my view, they are quite right to say that it's obviously unlawful for a local authority to have these kinds of pre-eligibility criteria, because the law is very clear that the local authority must assess every child who is or may be a child in need, and all disabled children are automatically children in need. Where eligibility criteria are then relevant is after the assessment. Are we going to provide services to this particular child? So it's difficult for me to understand why this seems to be such a prevalent practice, other than straightforward gatekeeping and cost reduction. The picture is made somewhat more complicated by the existence of early help as a concept. And early help is very prominent in the statutory guidance on children in need, working together to safeguard children. And I read that guidance very clearly as saying that what early help does is discharge the general cooperation duty on local authorities and other bodies in Section 10 of the Children Act 2004, which was the post-Victoria Climbié legislation requiring public authorities to work together to safeguard and promote the welfare of children. But that's something completely different to services for children in need. And although the guidance could be more clearly drafted on this point, I think it's tolerably clear that early help is just irrelevant for anyone who is or may be a child in need. And if it happens that early help and early help services are meeting your needs as a disabled child, well, that's all well and good. But if you want a child in need assessment as a parent carer of a disabled child, you are entitled to one without more. So my view is that those local authorities who are doing this are on very dodgy legal ground. And if anyone is affected by it, then they ought to get legal advice. So it's a great example, really, of the kind of thing that local authorities may end up feeling compelled to do, but will not be lawful. How far will it get you if, in fact, the answer to 99% of assessments is we're not providing any services? Well, yes, that's a fair point, but how can the local authority rationally decide whether or not it's necessary, even taking account of its resource constraints, to provide a service for a disabled child until they've done the assessment? So the legal process is clear, in my view. Okay, so what I suggest we do is take a quick pause there, come back at 1:10. We'll leave everything up and running. If anyone has any more questions, please feel free to put them in the chat. But otherwise, I suggest people just turn off cameras and microphones and take our short break and come back at 1:10. Thanks very much, everyone. Okay, hi, everyone. Hope you've made it back. Hope you are refreshed. I'll just see if there's anything else in the chat before we go ahead. So, reference back to an earlier question that I seem to have missed. Apologies for that. So it's concerning, yes, I've got it here, thank you. So if a local authority sets a budget that isn't enough to meet its legal duties. So that's a really interesting question. The case law on challenges to budgets, much of which I've been in, is that it's very difficult to challenge the setting of a budget, because a budget is only an estimate of expenditure. And if it turns out that the local authority needs to spend more money in a particular area in order to comply with its legal duties, then it's expected that it will do so. The Section 114 issue is not really about budgets, it's about realities, as in, is the amount of money that we are expecting to spend, regardless of whether or not it's budgeted, going to exceed the amount of income that we know we have? And so I don't think that it would be possible to say that you've not budgeted enough to meet your legal duties, because the legal duties that are non-resource dependent simply must be met. I expect that that's how that kind of challenge would be treated, because a budget, and this is the most prominent example of this, is a case that I was junior counsel in called Hollow and Surrey, is only an estimate of expenditure. And so even if a local authority is saying, well, we must not do this because our budget is only X, that's not actually reflective of the true position. If they're saying we can't do this because we actually don't have enough money, then that's a Section 114 situation potentially. So I think that's the answer to that very helpful question. Okay, so then I wanted to talk briefly about a real life example. And if there's anyone on the call from Birmingham, then this is your authority, I'm afraid. Birmingham is one of, well, it is the largest local authority in Europe. And of course, very striking that it has had to issue a Section 114 notice. And there's a case called YVR, quite recently decided, which was about charging for adult social care. People will be aware, I'm sure, that local authorities can charge for the vast majority of their adult social care services, and most but not all do. There are very complex rules around charging and how much a person can be charged for the care they receive. Of course, they can't be charged more than the cost of the care, but there are other limits as well, and one of them is a statutory minimum income guarantee, an amount that the person must be left with after the charging has been taken. And Birmingham, for some time, had been taking that maximum amount, leaving only the minimum income guarantee, as I understand it. There was a successful challenge to Norfolk County Council on the basis that a similar approach discriminated unlawfully against the more severely disabled adults who are less likely to be able to work, because income from work was treated more favourably than income from benefits, put very shortly. And so the claim in YVR was that Birmingham hadn't done anything differently in the light of the Norfolk judgment, and that the Birmingham policy was equally discriminatory and unlawful. And it was also said that they'd failed to comply with the public sector equality duty, which is a very common ground of challenge in these kinds of cases. And what the PSED requires is due regard to a series of different needs, including the need to advance equality of opportunity and the need to eliminate discrimination when a public body is doing anything at all. So, for example, here, setting its charging policy. I think it's very interesting to see how the court dealt with the financial position that Birmingham was in. So the backdrop to the policy review was the council's descent into unprecedented financial crisis. The council, like other local authorities, is required by law to set a balanced budget. The financial plan it published in January 2023, setting out its proposed budget, included a very bleak prognosis as to its likely ability to do so, identified a likely budget gap at that point of around 80 million. A series of causes were then identified, including those that I've mentioned in the introduction. So this is all from the judgment. On 5th of September 2023, the council issued its Section 114 notice. It was described by the barristers in court to the judge as the nuclear option, an effective declaration of bankruptcy or inability to balance the budget. The projected deficit now stood at 87 million. The consequence was a decision to impose radical spending controls and the cessation of all non-essential expenditure, but that was not projected to solve the problem in year. The central government intervened at this point and sent in commissioners to oversee the council. They reported on the 27th of February this year, just the day before the hearing of the claim in relation to the adult social care charging, to the effect that the council was in an extremely serious financial position as a result of the past decisions it has taken. While the situation was brought about initially due to the scale of the potential equal pay liabilities the council faces, this budget highlights wider and significant financial pressures and a fundamental structural collapse of the general fund budget. The council have been provided with 1.255 billion in exceptional financial support alone from central government to be paid back through asset sales. And there was a narrow path to financial sustainability dependent on making revenue savings of nearly £300 million over the following 2 financial years. There was going to be an increase in council tax charges. The council was instructed to pursue that 2-year plan by the commissioners, who of course were imposed to run the council. There are no other choices available, it was said. So this was then all the context, very unhappy context, for a claim which was, well, you're discriminating against severely disabled people in the same way that Norfolk County Council did. That the judge did not find it difficult, I think it's fair to say, to dismiss that claim, found that it wasn't discrimination in substance, and there had been no breach of the public sector equality duty. And I just thought it was quite interesting to pick out what was said by the judge here in relation to the public sector equality duty ground. So she was unpersuaded that on the basis that the substance of the decision challenge was justified, it could nevertheless be said to be vitiated by reason of procedural failure, including in relation to the public sector equality duty. The council considered the substantive aspects of the PSCD relevant to this challenge with real focus and anxiety. That was so even given the overwhelming nature of its financial predicament. It cannot in all the circumstances fairly be criticised, it's the council there, cannot in all the circumstances fairly be criticised for not thinking more imaginatively or in a more structured way about doing something else. And if ever there were a case for accepting an argument that no further degree of procedural rigour would in any event have produced a different outcome, it is surely the present one. And I think that last sentence is incredibly important, really, in terms of dealing with the reality of a Section 114 situation. The reality was that everything that Birmingham didn't absolutely had to do would go. And where Parliament has legislated for something, or the regulations and the guidance mandate something, i.e. in that case, the minimum income guarantee, it's very difficult to succeed in a challenge that says you should be doing more than the bare statutory minimum. Even if in other situations, i.e. Norfolk, which wasn't a Section 114 authority, and I don't think is still, it would have been held that that was a discriminatory approach. So the reality is that trying to challenge anything that isn't absolutely nailed down by a specific legal duty in a Section 114 context is going to be very difficult indeed, if not impossible. I don't know if YBR is going on appeal, but certainly the first instance judge was absolutely clear that in this particular context, there was no basis for criticising the council. So I thought that was possibly slightly depressing, but a very helpful point to emphasise in terms of where potential challenges might be in the Section 114 context. It's unlikely to be to the decision to issue the notice. It's going to be to the consequences of that, or it's going to be to adverse policies that are continuing in that context. But unless they're really very harsh indeed, chances of succeeding in a claim like that, I think, are going to be low. So where do we think there are going to be attempts to find savings in our area? Well, I think the most obvious are the two that I've put on the slide here. So first of all, school transport. We know that in rural areas in particular, school transport budgets are incredibly high. There are some stories of councils spending more on transport than on substantive SEN provision. The law and guidance on school transport is complex. The entitlement, even for those of compulsory school age, is based on a series of potentially overlapping eligibility criteria. For example, the distance criteria, living too far from the school, but also for a child who's disabled, not being able to walk to school safely, could be a criteria. So you can be eligible even within the statutory walking distance. But very many disabled children will be educated more than 3 miles or 2 miles from their school, of course, because of the lack of a closer and nearer suitable provision. So it's very likely, I think, that we will see more restrictive policies attempted for school-age transport, more of an emphasis on parents taking the child to school. There's been some very good work by SOS, SEN and others on the new guidance, which it's said doesn't properly reflect the fact that, for example, if you've got a single parent with 3 children, one of whom is disabled, it's physically impossible for him or her to get all those children to school at the same time. So I can see a real issue around how far exactly does the duty to provide school transport extend, even to the group that people understand have that duty and have that entitlement. And then, of course, post-16, it's the Wild West, isn't it? And some local authorities really don't seem to understand that they have any obligations to the post-16 cohort at all. So I can well imagine that will be an area that local authorities simply seek to cut or stop spending money on entirely. And again, if that happens, there will definitely be a need for legal action, because the picture is actually much more nuanced than that. And I think the effect of the legislation, the complex legislation, is that local authorities do continue to have a duty to provide school transport, or post-16 transport, I should say, up to 25 for those with EHC plans, where it's necessary for them to do so. Yes, we will end up, I think, in that argument again about just what does necessary mean, but there will be some cases, the hardest cases, where it's obviously necessary and no reasonable authority could conclude otherwise. So that's what I think we will end up seeing in that area. In the second group of likely areas of saving around SEM placements, I think the safety valve agreements has obviously been the area that has attracted the most attention. There are some authorities that have, or at least a handful, that have refused to enter into the safety valve agreement. Bournemouth, Christchurch and Poole, publicity has said that they didn't enter into the safety valve because they considered that they couldn't do so in a way that was consistent with their legal duties. However, I think that we will see attempts to do much of what's in the safety valve agreements in other areas as well, even if their particular high needs block funding deficit is not great. If they're just struggling financially generally, then this is an area that will be explored, shall we say, because so much of the more obviously discretionary expenditure has already gone. I think that's one of the really difficult things about this area at the moment, is that the low-hanging fruit, if you like, the nice to haves, the things that make life good in terms of culture, for example, leisure, even the frequency with which the bins are collected, much of that has already been done. And we are now dealing with a situation where local authorities have to make genuinely extremely hard choices, and where their freedom of movement is constrained significantly by hard-edged statutory duties. And so I do think all areas will be looking at whether or not they are required to pay what seems to be, and in some cases are, exorbitant fees. There's work going on in terms of profiteering in children's services more generally, in terms of placements and in children's for looked after children. My experience is that there are a wide range of providers in the private sector, in the independent sector, and it's often the best ones, or the ones that we would most like to be educating or caring for our children, that are not the ones that are profiteering or trying to put up prices excessively, but actually are just trying to establish a sustainable level of fee that will allow them to keep operating. So it's again going to be very incumbent, I think, on parent forums to try and understand where in local areas the vulnerable providers are, who the forum thinks ought to be supported, and who parents want to continue to be available for children, and make sure that they are supported to get an appropriate fee for the placement. I'm afraid there will be others, and I'm very happy to take questions on what they might be, or concerns people might have about any particular areas of service that we might see. One of the things we haven't discussed today, of course, and that's because this is about Section 114 notices, and that's a local authority procedure, is NHS services and support. Now, of course, there isn't the equivalent of a Section 114 process for NHS bodies, but we do know that NHS budgets are also under significant strain, and so therapy services, continuing care, may also see restrictions placed on it. And so, again, any questions about that may be relevant. I think it's important to flag the cooperation duties that exist between local authorities and the NHS, and the fact that in any case where a child is eligible for NHS support, that doesn't mean that they're not the responsibility of the local authority anymore. It just means that at least some of their needs go across the line and can only be met by the health service. But there needs to be consistent cooperation between the local authority and the NHS in those particularly complex cases. I see there's a question in the chat, so I'll take a brief pause, stop sharing, and see what that question is. Okay, so a really interesting question. How do we find out about what the post-16 transport policy is? How do we find out what exceptional circumstances are? Well, that's a very interesting question. So in terms of the first part of the question, which is how do we find the policy, there is a requirement on local authorities to publish probably all their policies, and certainly a specific requirement to publish their post-16 transport policy statement. And it should be identifiable through a search using Google or any other popular search engine. If it's not, that's probably unlawful itself. So once you've found the policy statement, which has to be published for each year, it should tell you when services are going to be provided post-16. And if it says, for example, only in exceptional circumstances, you might want to contact a solicitor, because it seems to me that that's not consistent with a duty to provide services or provide transport where it's necessary. Someone could have a non-exceptional need for transport. So I don't accept that in exceptional circumstances is synonymous with a duty to provide transport where necessary. And then the follow-up question is, well, how do we know if they've implemented a blanket policy and refused all post-16 transport? That, again, I think is where the forum is so important as a resource, as an information sharing resource, a support hub for parents. If template letters are being issued that all say the same thing, that's a very strong suggestion that there is that kind of blanket policy in force. If the letter doesn't have any proper reasons, doesn't refer to the circumstances of the individual case. There are, of course, appeal processes in relation to transport, and the expectation is that those would be followed. But I think there's a really interesting question about what happens where those appeal processes are in place under a policy which is at least arguably unlawful, whether you can challenge the policy itself. And the answer to that is yes, you probably can. So again, it's well worth taking advice in those cases. And then a question about, which I think is relevant to this talk, because again, it's a way in which local authorities will seek to reduce expenditure, where they're discharging their duties in relation to social care by making a direct payment. And of course, people will be aware that that's all a direct payment is. It's a mechanism to discharge the duty to meet the child or the adult's eligible needs. Where the family can't recruit a PA or can't otherwise use the money, it's usually recouped by the local authority, and therefore they make a saving. And I think in principle that is permissible. The consequence of that is that there will be a period of time for which the child's needs are not being met. So the child will have eligible needs and the local authority isn't in fact meeting those needs. And then the question is, well, is that because there's a short gap in recruitment and the family think, well, that's still the better way to do it and we're going to continue with that approach? Or is it because, in fact, the local authority isn't offering a direct service and the direct payment is the only way that the needs can be met? Because if it's the latter case, then I think that there's a good claim of illegality there on the basis that there's a period of time for which the eligible needs are not being met. But if it's the former and it's an unfortunate practical issue, that's not something the court is going to get involved in. But I think it is the case that things like rates, fixed rates for direct payments, caps on the amount of support, all of which the case law says is unlawful, but are likely to be more prominent in the coming period in those areas that are experiencing the kind of financial constraints that some of the authorities are. An excellent question that's just come in. So in terms of legal obligation on local authorities to fund co-production with families via parent carer forums, and that, of course, one would expect is an area that local authorities will be looking to cut funding on because it will be seen as discretionary. I'm not sure that there's any specific obligation in that area. I'd have to look into that. But of course, under Section 19 of the Children and Families Act, in exercising a function in relation to any child or young person, the local authority has to focus on the principles of co-production. And it would seem to me there seem to be a number of potential grounds of challenge to a decision to cut or reduce funding to the parent carer forum. I'd be very interested in speaking to anyone who's in that position. But I don't think I certainly can't off the top of my head, give a straightforward answer and point to a particular statutory provision that says the local authority must fund the parent carer forum. Any other questions at this point before I jump back to the slides? Okay. Oh, good. Okay, I had reached the end of my slides. Good. So those were the areas that I thought I particularly wanted to highlight. Very happy to take any other questions about other areas that people might have that they would like me to focus on. Otherwise, there were a couple of resources that I wanted to flag up for everyone, and I'm going to do that now while my screen is not being shared, so I don't breach anyone's confidentiality, and answer a question that's come in while I do it, which is expand on the relationship with health. So I think the short answer to that is that if you're ever wondering, is there a duty on the NHS and the local authority to cooperate in this situation to promote the welfare of the child? The answer to that question is yes. There has not been a piece of social welfare law passed in the last 15 years, I would suggest, that doesn't require relevant bodies to cooperate with each other, because Parliament has recognised that there is a major problem with people falling through the gaps between different services. And so the key duty, I would suggest, the one that probably is the starting point for most, if not all cases, is that duty I mentioned already in Section 10 of the Children Act 2004, because that requires all the relevant bodies to cooperate with the goal of safeguarding and promoting the welfare of children. There are more specific ones as well in certain contexts, for example, in the Children and Families Act itself. But it can be safely assumed that in any given situation, the relevant NHS body and the local authority and the school very often as well, are expected to cooperate, and it won't be lawful for them to simply point at each other and pass the buck. Okay, please do again add any further questions. I will also then just share a few resources, one of which that I perhaps should have started with my plug, and I hope will be familiar to many, is our handbook. So I'll put the link in the chat for those that are following live. And I'll share the screen as well, so those that aren't can see it. The handbook is intended to be a comprehensive overview of the law in this area. And one of the things that we really focused on when we were producing it, and this is the online version, of course, is to identify where are the hard-edged legal duties. So we provide in each of the chapters a summary which really emphasizes those. And you'll see that there are chapters in relation to each of the areas of service that our children and families need. But there's also, I think this might be quite helpful in the current context, a chapter on legal fundamentals. And what that does, amongst other things, as we see here, is look at this distinction between powers and duties. So if that part of the talk, which is really fundamental, was a little bit technical, and you want a refresher, I would recommend this part of the book to you in terms of understanding the distinction between between duties and powers, and also between different types of duties, and the critical importance of specific duties that are not dependent on available resources. So that was my first plug. The second one I was going to share is the list of solicitors. Now, again, I make it clear that this is not in any way recommendations. These are simply some of, and there are others, the firms that have some expertise in this area. And many of them have the relevant legal aid contracts. I list those as legal aid contracts here. And I think it's really important that families know where to access those. Not because we're trying to drum up business. I would stress that all the lawyers in this area who are any good are well and truly busy, if not oversubscribed. So it's not that there's more cases that need to be brought, but that in reality, unless you can access a solicitor with the relevant legal aid contract, you are not going to be able to bring a claim for judicial review. So you do need to know where to go and find legal advice in a situation where you may feel that a legal challenge is necessary. And of course, we need to understand a bit more about judicial review as well. And so on the blog, I've produced a basic guide to judicial review, which again, I'm putting in the chat now. Will hopefully appear if I do that. Yes, good. To explain how it works. And I think there is this very nice quote from Lord Justice Sedley, which gives the really baseline explanation that actually judicial review isn't about people's rights, it's about wrongs. It's about when public bodies have gone wrong. And the function of the administrative court is to seek to put that right, to correct legal errors by public bodies, as opposed to getting involved in the merits of the decision. So although it's very unlikely there's going to be a successful challenge to the decision to issue the Section 114 notice itself, what the local authority then does to seek to balance the books may well result in arguable unlawfulness and need challenging. I think where it's something like the minimum income guarantee case against Birmingham, that's going to be particularly difficult. But if it simply cuts across a statutory duty to provide a particular service, then there is a real prospect of the court getting involved. So those two links to my blog, I hope, are useful resources for people who are concerned about potential unlawfulness in local areas where, in local areas where finances are tight is 100% of the country, but particularly in local areas which either have or may be considering issuing a Section 114 notice. One thing I'd be interested to know is if there are colleagues who actually already have a Section 114 notice in force in their local area, and how that, if at all, they have seen that make a difference to the way in which services are provided. I think it'd be really interesting to hear for anyone who's in that position. While if perhaps anyone wants to have a think about that, I'll take the next question, which is about the relationship between local authorities and health. And is there a level where instead of providing a joint service, the level of need is too high? And so there should only be a health service. And the reference there is to the Haringey judgment, which is a very long-standing case now involving a young child with a tracheostomy, where the court said that it was only the NHS that could provide her with, quotes, respite care. So the answer to that question from the Haringey judgment is yes, there are definitely some cases where the level of need is so high that only the NHS can provide some or indeed all of the care. It would still be expected, of course, that the local authority would be providing education, but the care can only lawfully be provided by the NHS. And I'm aware of cases where the local authority is at least arguably going too far and is for good reasons, for well-intentioned reasons, providing services that are arguably unlawful because they are essentially a health service. And so, for example, a very obvious indicator of where we may be going across the line is registered nursing care. And the well-established inabilities of local authorities to provide anything other than ancillary, as it's called, a modest amount on the side of registered nursing care. But that's not always followed in practice. So thank you for one colleague, I won't name which area, saying that they have the Section 114 notice, that they've also got a written statement of action and a statutory direction. So yes, they've got the full house. What would be really good to hear in the chat, or indeed if people want to come in live, is what it's meant, if it has indeed, in fact, changed the way in which services are being provided. You know, being frank, we know that these are services that have been cut for 15 years now. So does it make that much difference to have a Section 114 notice in place? Are there actually any local authorities who in practice are providing anything above the statutory minimum now anyway? It's hard for me to know because, of course, in my position, people only come to me when things are going badly wrong. So if things are going well, I'm unlikely to hear about them. So it'd be really interesting to hear, again, if people think that the fact of a Section 114 notice being made is likely to have made, or has in fact made any real difference. My hypothesis, as you can probably tell from my introductory remarks here, is that it won't, because that's pretty much what the experience that every local authority and every resident of every local authority is having already. An interesting question: could every local authority in the country issue a Section 114 notice? Yes, there's no limit, and in fact, there's a mandatory requirement on the chief financial officer to issue a notice if he or she considers that the expenditure is going to exceed income. So it's very likely that, well, it's very likely, in fact, I would say verging on certain, that we will see more. I think it's unlikely that every local authority would get to that point, because surely at that stage, central government would have to accept that local authorities generally were just under-resourced. But it's certainly a theoretical possibility, a legal possibility, even if probably not a practical one. Thank you for the comment that, again, I won't name the area, that the imposition of commissioners made things worse because there was then a difference in the politics of the council and the commissioners, who of course are imposed by central government. And I think that is very important, isn't it? Because it's not a neutral event issuing a Section 114 notice. Something's gone badly wrong. It's someone's fault. It's probably many people's faults. But the political endeavour will be to blame someone else, of course. And so the blame game, as the question helpfully puts it, is very real, I think, and distracting, of course, from the business of actually providing services. Thank you for another helpful comment, that it's impacted on morale. I think that's really important, because it does, it feels like a total failure, doesn't it, of the local area. And when people are imposed, and within the same comment is a very helpful point, that we then have a degree of removal from locally elected people being responsible for the commissioning of services. And that's a real difficulty, I think, because in terms of accountability, you can't vote out the commissioners. So that's a massive problem. And it does, I think, also emphasize how we do live in a very centralized state. And although there are lots of ways in which we look to have significant local decision making, actually, when push comes to shove, the centre can kick out those elected people and impose commissioners if things have gone badly wrong. So I can totally understand that. An interesting point within that comment that I'll just pick up: the voluntary sector is trying to meet need. There isn't a framework legally for this. One of the things that I would want to stress is within the Care Act, there is a duty in relation to what's called market shaping. Section 5 of the Care Act requires local authorities to commission services in a way that promotes an effective market in terms of high quality available services. We don't have the same specific obligation for children, but I think you can read it across from the Care Act as well. And actually the voluntary sector can, things like the best value duty, for example, on local authorities do require effective commissioning of local services. And that doesn't stop just because a Section 114 notice has been issued, although it will be assumed that the services that are going to be commissioned are only those that can that meet specific duties. So in terms of providers, they will need to orient themselves towards what they understand to be services that have to be provided, where the local authority have got no choice. But what exactly those are is, again, a matter of some debate. And then, yes, to add to the complexity, things like elected mayors, the structures change and evolve over time. But I do wonder if some of this is really window dressing, to the extent that if the local area just hasn't got enough money to meet needs, it doesn't matter how you organise the commissioning or how you organise the administration, the funding just isn't adequate to deal with the statutory demand. And I think that's a really important point about, for example, the Children and Families Act, which only reflects the previous law in relation to education, at least, is that the financial demand that it creates is limitless. There's nothing in the legislation that says that at the point that a child's needs cost £100,000, £200,000, £300,000 a year, we stop and we say, no, we're not meeting those needs anymore. The duty is, in short, to meet needs in the most cost-effective way. But for some children and young people, that will be a very large figure. And it does feel to me that what we're seeing now in terms of Section 114 and the financial crisis in local authorities, in part, not entirely, is the consequence of legislation being passed without the financial backing that is necessarily required to make it real. And that's been a theme of my practice since 2008 when I became a barrister. Is it's all well and good having these duties, but unless there's resources allocated to have services to provide for people's needs, they're just words. And now we're seeing the chickens come home to roost, I think. A very fair comment in the chat that funds need to be managed effectively. Absolutely, of course. And I think that would be the criticism. And there's an interesting report by SIPFA, the public sector accountancy body, looking at some 3 case study authorities, essentially saying, this is what they did wrong. This is what we need to avoid doing. I'm not for a moment suggesting that there's one cause of these kinds of crises. But I do think as a society, we haven't grappled with the fact that meeting some people's needs is just very expensive. It doesn't matter how efficiently you do it. And that if we're going to honour the principles and indeed the duties in the legislation, there just needs to be more money in the system. I say that as a lawyer, not an accountant, but I certainly know of packages that are, I think, well beyond the amount of money that would have been expected by the people passing the legislation, even as recently as 10 years ago in 2014. And I think that has to be grappled with, or else we will never get out of this loop. Okay, well, we've got about 10 minutes left, so I can take any final questions. Otherwise, I'll just give a couple of concluding thoughts, and I might just think, I was going to jump off the slides, but I think I've made the point. The concluding thought that I wanted to leave people with, I suppose, is the Douglas Adams quote from Hitchhiker's Guide. It's don't panic. I think that the effect of being in an area where a Section 114 notice has been made, or perhaps even worse, is about to be made, must feel a little bit like the Titanic hitting the iceberg, and there aren't enough life rafts. It's not actually like that in legal terms, because my hypothesis is that most local areas were only doing the legal minimums anyway. And so the message for forums, and the message that I think forums need to get out to parents more widely, is that anything that the council had to do by law before the Section 114 notice was issued, they still have to do. It's only the things that they didn't have to do but were choosing to do that they can stop doing and question whether there's much, if any, of that anyway. And I think if there's one message to take away from the talk, it's that in fact, it may be that issuing the Section 114 notice doesn't change that much legally. And I think it's really interesting that the very helpful comments we've had in the chat suggest that what changes is how things feel, and the morale and the attitude. And I understand that, and that's really important, but it's not as important as the law. And if you can find alliances and ways to work with lawyers to enforce the law, then that will trump anything that we're talking about today in terms of local authority processes and attempts to save money that go against statutory minimums. So I hope that in what is a very depressing context, that provides some form of comfort, at least, that it's not as if the issuing a Section 114 notice suddenly removes all the local authorities' legal obligations, nor does imposing commissioners or anything of that sort. The law remains. The question is whether it's complied with, and if it's not, how that's challenged. And I hope, and I know that parent forums will be an important part of that. And I hope today's talk has been useful in terms of providing some resources to do that. So and there's an important point around the consequences of co-production, and whether in a context where Section 114 notice has been issued, there will be less co-production. I think that must be right, not least because you're going to get these top-down directives in many cases with the imposition of commissioners and so on. But looking at all the preparatory work that was done for the Children and Families Act, one of the reasons why co-production is such a central theme for the 2014 legislation is because it works. Because if you don't co-produce things, they're not as good and they're not as effective and they don't save money. So ultimately, in a local area that abandons co-production, it's very obvious what's going to happen. Things are going to get worse and more money is going to be wasted. So again, I think that's a very important message for parent forums to push back on, that this is, you know, short-termism in the worst sense. And potentially, if there's a complete, you know, volte-face or complete failure to co-produce, consider legal challenge. So I think, unless there's any further final questions, I can probably hand back to our organisers to draw things to a close. Just echoing our last comment, and thank you for all the comments, guys, because, and I haven't named people because of confidentiality reasons, but they've all been really, really helpful. And the last one, which is the forums have to be strong and keep going. And I couldn't echo that anymore. I've always been a huge advocate of parent forums, a huge supporter of your work. And I do genuinely believe that where things get better, it's very usually because of the active and engaged parent forum that's driving it. And I hope that you can continue to do so in these difficult times. And I'll be here cheering on and available to help as and when required. So I'll hand back to Sarah now.
Thanks, Steve. Just huge thanks to you and to everyone who's joined us and taken part in the discussion and just been a lovely active listener. Thank you so much for everything that you've done today. I think it's provided a lot of information, a lot of food for thought, and I'm sure a level of kind of maybe hopefully sort of keeping people going and a bit of resilience to keep going through what challenges may lie ahead. So thank you very much for today. It's been really, really helpful.
Thanks, Sarah. Thanks for having me, and thank you to everyone.
And I guess we'll draw things to a close now and close the session for everybody. Just to flag up that there will be a survey come through to you. Please complete that to give us your feedback. It's really helpful when we're looking at what sessions to do next and how you found today. And that will be sent out direct via email to everybody who's joined. And the recording and the slides will be available after today's session, but just give us a day. All right, thank you, everybody. And I'll now close.
Yes.
Thanks, Steve.
Bye, everyone.
Bye, everybody.
Bye, everyone.